So this video is really for anyone who is involved in the annual Rough Sleeper snapshot, and basically anyone else who might be interested in how a sector gets something really badly wrong, and the fact that everyone does it just kind of ends up perpetuating the issue. So the issue here really is about data breaches, and as I'm about to explain, if you follow the guidance from Homelessness, I think there's a strong chance that you're going to end up breaching the rights of the people you are trying to help out. So it can be done legally. So in one sense I want to point out what's wrong, but also say how you can actually do this snapshot exercise properly. And it's probably worth going into a bit of background first. Every year for, I don't know, approaching 20 years I'd say, there has been this Rough Sleeper count or Rough Sleeper snapshot, and essentially the government is trying to establish, we see rough sleeping's rising, but we want to know how much it's rising by, so there's a particular methodology. And so every local authority district in the country, so there's more than 300 of them, have to provide a verified figure back to central government. It's then published in usually sort of February, March every year. And in order to do that, local authorities work with partner organisations. So often there's going to be thousands of organisations actually involved in generating this data. And it's obviously difficult to exactly know how many people are really rough sleeping, which is why the methodology is kind of fairly consistent. But in order to do it, every local authority in effect acts as a hub to kind of gather this information together. And as part of that, lots of charities, lots of other organisations will also be processing the data of people's rough sleeping in order to kind of get an accurate figure. And so Homelessness is kind of the go-to place for guidance on this. Homelessness is, I think, a charity which acts as a bit of a go-between between central government, local authorities and then charities. And I don't envy their job. In one sense, they've got a real difficult position to play there because of the politics of it all. There's lots of competing kind of forces at work there, lots of tensions which they have to try and manage. But in the case of rough sleeping, this rough sleeper estimate, I think there's problems, and I've raised this with them properly a couple of years ago now, and they have improved things. But I've just looked this month at the most recent methodology and the kind of guidance, and there's still some really big issues there. I would say there would be serious breaches of the Data Protection Act if this guidance was followed, and it matters for a lot of different reasons. I know a lot of people, when they hear data protection, they roll their eyes. I used to. Everything I'm about to go into in this video, I used to do myself. So I've coordinated counts, I've chaired multi-agency meetings. Everything that we're talking about here, I got wrong. So I'm kind of not trying to shit on people here. I'm just trying to point something out which I think is quite important. In fact, I think it's very important. And as I say, kind of give the pointers of how it can be done properly. Because if this is done badly, what really happens is that lots and lots of vulnerable people's personal data, including special category data as we'll see, is processed without their knowledge. And if you're really kind of cynical, there's a lot of money involved that exchanges hands as a result of these figures. So I won't name which local authority it is, but I'm aware of a situation a few years ago where there was a count meeting, I'll talk about these terms in a little bit, where the local authority representative who was chairing the meeting basically told the partners that the higher the number of people they reported rough sleeping, the more money they would then get from central government. And just by coincidence, that happened to be the highest single number of rough sleepers they'd ever counted, which then went down in subsequent years. So yeah, a lot of money is at stake here, and it can basically shape how services are delivered around the country, so it's important, basically. Let me give you a bit of a background of how it actually works in practice, because it might just help give a bit of context. So what happens is every October, November, local authorities and their partners set a date at which point they're going to essentially kind of estimate or count how many people are sleeping rough. There's a particular definition of sleeping rough, which I'm not going to go into here. So they'll kind of set the date, they'll then disseminate the information, they'll tell each partner what's involved, what they need to do. The date might be, let's say, the 30th of November. And on that day, every organisation is supposed to try and find out how many people were sleeping rough that they were aware of. Often what then happens is there's a meeting after that date, where, often the day after, where those same organisations will come together in one room and they'll share lots of personal data in order to corroborate who was actually sleeping rough, what the real numbers are. Part of that's to avoid duplicating counts, because it might be that 2 people were known to 3 different services, and that can either be counted as 2 people or 6 people depending how well they do that verification process. So there is a reason for doing this estimate in the first place, this snapshot, and there is a reason for processing data in some way. But we very quickly run into problems after this, and I might do an appendix at the end of this video which looks at Martha Nussbaum's work on the objectification of humans, because I think actually we get a lot of good stuff from that. It's not essential, obviously, so if you don't want to watch that bit, it's cool. I'm just going to go through the Homeless Link guidance and explain what the problem is and what you can do about it to avoid falling into that trap. So I think that's all I need to say at this point. I've got a few notes here because it's a little bit complicated. But basically, if you haven't been on Homeless Link's website yet, do so. There's some brilliant resources on there about trauma-informed support, that sort of thing. But there seems to be a couple of blind spots. One, particularly around kind of homeless people's rights. So, for example, if you search on the website for the term gatekeeping, which I would say is probably the most important term when it comes to understanding homelessness, it only mentions it in passing a couple of times. And again, we see this kind of idea of rights of under data protection law, under human rights law, really. There are some big howlers which in my opinion, should be put right ASAP. And as I say, I've been to them already. They haven't done it. What else am I supposed to do here? My aim here is to help people not break the law. That's kind of what I'm looking to do. Now, on the guidance pages on the Homeless Link website, not sure who authored them. I don't know if it was actually someone from Homeless Link or someone from MHCLG. Sorry for the jargon. MHCLG is the Ministry of Housing, Communities, Local Government. That's the kind of government department which kind of defines how homelessness is dealt with in England. And I'll flash up a few pages here and kind of set the scene as to what problems we've got here. So this page here, for example, sets out what the snapshot's for. I'm not going to read it all here, but I'll read the the third paragraph, which says that where demographic information is not known, for example, because someone was asleep when seen, this should be noted for each category as not known. The demographic data is collected as an indication of the representation of particular groups among people who are sleeping rough. There is no requirement for people sleeping rough to share their information for the purposes of these statistics, as not known can be used instead. So, I don't know why they wrote this. This causes some big problems. One of the most important principles within data protection law is this idea of data minimization. So essentially it's this kind of idea of need to know. So if you don't need to know something, if you don't need to do something, you shouldn't do it, even if you might otherwise have a lawful basis to do so. So for example, you might have the consent of someone to share data with an organization, but if you don't need to share it in order to achieve your aims, in this case the aim is to work out how many people are sleeping rough, then it is unlawful to do so. It's a breach. Now, I've been involved in a number of breach compensation claims over the years, most recently this year, which involve very similar kind of situations here. And it's often the data minimization principle that organisations get wrong first. So, as I say, I don't know why they wrote this, but they're basically saying you don't actually need to process personal data in order to achieve the aims of this exercise. Now, actually, I don't think that's quite correct. I think in some cases you will need to process some data at least in order to establish, you're not double counting people and make sure everyone's included. But the fact that they're saying this, essentially I would argue that it would undermine everything that they subsequently say, because what they're really saying is, although you are expected to record various kind of demographic details about someone, you don't actually need to do it in order to achieve the aims of the exercise, so you shouldn't actually legally do it. So that's our first problem. I'll introduce at this point as well data sharing protocols or data sharing agreements, because it references data sharing agreements. And data sharing agreements are simply local policies which partner organisations sign up to and create the illusion sometimes that the law is being followed even when it isn't. So in the breach I was involved earlier this year, actually, there was a data sharing protocol in place. It just wasn't lawful. It was basically by definition unlawful. So by following the data sharing agreement, organisations were automatically breaking the law. So the fact that your organisation might have signed up to a data sharing agreement doesn't actually stop you breaking the law at all. You need to know that the data sharing agreement has been competently written, and I've seen loads of these kind of protocols and policies which are simply just not written by anyone who knows anything about data protection. So if I was a chief exec of a small charity, I'd be very reluctant to be signing up to anything, and I'd also be taking advice and getting my head around data protection law. I appreciate for small charities you've got to be the jack of all trades, and actually data protection law can get quite complicated, and therefore your approach should be very, very kind of slow and kind of and conservative. You should not be jumping in and processing loads of data unless you're very confident you're actually doing it legally. Now, in the data sharing protocol or agreement, it will often say what the lawful bases are of the rough sleep account or snapshot, And interestingly, I couldn't see reference on Homelesslink's website to the lawful basis. So in order to process personal data, you need to have some basis on which you're doing it lawfully. So often it's going to be consent. So you have got the consent of that individual, it's informed, they know what they're doing, and they've given you consent for you to speak to their doctor about X, Y, and Z. And that basically provides the basis by which you then share data with the GP. That makes it lawful. There are other bases that are not consent, but one of the ones you often see in these kind of settings is this idea of public interest, or substantial public interest potentially. And I'm sorry to have to complicate things here, but I guess I can't explain this very well unless I do so. Public interest and substantial public interest are two bases that you might in theory be able to use. One applies to sort of generic personal data and one applies to special category data. We're going to talk more about this in a moment, but basically, as we'll see shortly, the data you're sharing, or the guidance would suggest you will be sharing as part of this snapshot count, does actually involve special category data, even if it might not look like it does at first glance. So often you have organisations within substantial public interest, they'll be using terms like safeguarding. They're processing data to safeguard those individuals. That is a complete misuse of that kind of understanding there, because you can only use safeguarding as a substantial public interest characteristic if that person is unable to give you their consent. So that's not going to apply most times, because most homeless people have capacity to give consent. And as I've said already, actually, you might have that person's consent to share data with the GP or any other organisation, but you can only then do so if you have an actual need to do so, if it's actually necessary as per the data minimisation principle. So there's lots of problems that kind of get introduced by these data sharing agreements. The lesson here to learn is that just because there is a formal looking policy that you've signed up to does not give you a carte blanche excuse to share data in lots of ways that actually aren't lawful. So I'd be asking who the author of that protocol was. Was it someone in the legal team? Was it with someone with a special knowledge of data protection law? Because actually it's quite a nuanced and niche kind of area of law, in order to kind of have confidence in it. And as I say, it might say something in the policy or the protocol, but that doesn't make it lawful to actually then go and do if it's not within the law. So as we've established here, it's basically saying that actually in theory you could achieve the aims of this exercise without processing any data at all. And we've talked here about data sharing protocols. It's probably now worth just explaining what special category data is and why this count methodology does involve special category data. So before the 2018 Data Protection Act came in, it used to be called sensitive personal data. Now it's called special category personal data. It's basically the same thing. It's a little bit more kind of like separated out, but you can kind of think of it as this idea of that certain types of data will be more sensitive by their very nature. So special category data is listed, I think there's 9 different criteria. Racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, data concerning health, data concerning a person's sex life, and data concerning a person's sexual orientation. And for all intents and purposes, certainly for this video, it's worth understanding that data relating to committal of offences, like criminal data, for all intents and purposes would kind of come under this special category data as well. Now technically it's a standalone, but we're not going to worry about that right now. Now this matters because the data that Homelesslink advise that you share, as I say, on the surface doesn't look very sensitive. So last name, first name, date of birth, gender, nationality, agency involved, evidence that the individual was rough sleeping in the local area on the agreed typical night, and then it lists the type of agencies that might be involved, so outreach teams, advice agencies, social services, youth work and so on, drug and alcohol support services, probation, health. That's probably the most relevant ones there. Some of those charities might involve sex work charities as well, and this is significant because if you report that Joe Bloggs was sleeping and that the agencies involved are the community mental health team, the GP, the pain clinic at hospital, probation, drug and alcohol team, something like that, you're basically saying that Joe Bloggs has mental health issues, has drug and alcohol issues, and has an offending history. Those are all sensitive types of data, to use the kind of non-precise term. And so this therefore becomes special category data. Not in every case, but in a lot of cases, you will therefore, by putting these different bits of information together, you'll be able to see that it's special category data. that basically makes the breaching of it much more serious, because it's much more sensitive stuff. And yeah, let's give the example that I became homeless. Let's say I had a mental health breakdown, I became homeless, became rough sleeping, I'm sleeping in my car somewhere, and some kindly person, some member of the public sees that I'm sleeping in a car, they refer me through StreetLink to the council. Let's not even talk about StreetLink right now in terms of data protection stuff, I'm not even sure how that works. The council then contact the rough sleeper outreach team, who then come and meet me, say, hey Mike, how's it going, we're here to help. So I give them some details, I don't quite know what it's involved, I've obviously got a lot on my mind at that point, and it happens to be on November 30th when this particular local authority is doing the count. And so the day after the November 30th, there's this big multi-agency meeting, and in that meeting they verbally share the fact that I am rough sleeping in my car at a particular location. And in that meeting it's attended by lots of other people. Now, as it happens, I know lots of people in that meeting because I worked in the sector, but that's not the only situation where this would arise. Now, clearly I would object to the fact that the fact I'm sleeping rough has been disseminated in this way, without a lawful basis, probably without my knowledge really. And even if I did sign some consent form somewhere, clearly that does not enable organisations to be sharing more data than is necessary to establish the aims of the exercise. And it's interesting that still on the Homelessness website, it still says that name and date of birth are not considered to be sensitive personal data. So that's the old term. I think this is literally, the sentence was carried over from the previous guidance. But the fact that an individual is sleeping rough and the evidence of this fact is considered to be. Now, that's not legal, but it is good practice. It is good practice to treat the fact that someone is sleeping rough as being that sensitive type of data. Notwithstanding the health issues, potentially the drug and alcohol issues, the offending history and so on that would also be involved. So these are where our problems really start coming through. So in following this Homeless Link guidance, you will probably be processing special category data when you don't need to, and you'll be sharing that with organisations that have no reason to know. The data breach case I was involved in earlier this year, one of the key kind of breaches was that very sensitive information about a female was shared with Bedford Prison, which is a male-only prison. So there's no way on earth they had any reason they needed to know that information. That formed part of the breach. It was obviously bigger than that as well. So we don't have a lawful basis stated on the Homelessness website as far as I can see. I would question the lawful bases that are listed in the data sharing agreement or protocol, because they probably don't actually apply. And you've then got these situations where the data, the potentially special category data of very vulnerable people are being processed in a way which they're not actually fully aware of. They wouldn't be happy with, or any reasonable person would not be happy with the way that's been shared, and there is no need to actually do so in order to achieve the aims of the count. So what this means practically is that if you're involved in these kind of rough sleeper snapshot exercises, you want to check out the data sharing agreement straight away and do your own research. Does it look legal? Often it won't be. I think in every case it won't be, to be honest, because of the way they're formed. And you therefore need to take responsibility for what your organisation does and what data it shares, because your overarching principle is you share as little data as possible, you process as little data as possible to achieve the aims of the snapshot, which is to establish how many people are sleeping rough. So if you're aware of 2 people who are sleeping in a car on a particular road, that is all you need to know. That is all you need to tell this kind of central hub, the local authority, in order for them to establish that those 2 people are not being double counted. Now, if you were to provide an information to say there's 2 people sleeping in a car on this road, and then another organisation provided information which says that there's 2 people sleeping in a car on this road, the local authority might then need to drill down a little bit with those 2 organisations to establish that they're not the same people. I mean, there probably will be in that situation. There might not be. There might be 4 people. So it'd be down to the local authority to then distill that out. But that can't be done in an open plan meeting where you've got lots of other organisations involved. So there's a lot to this. In those meetings, I mean, if it was me, I would not even attend those meetings. You're just going to get information which you have no business to know. Because if you're sitting there and 2 other organisations are kind of giving information about a particular person who's rough sleeping, that's not your business. You should not have your nose in that thing. And particularly when they start talking about, this person's under CMHT and whatever else, you are yeah, you're going way beyond what you should be. You know, that person has a right to a private life. You are sticking your nose into someone's life in a way that they would not be happy with. I mean, the ultimate litmus test for are you processing data lawfully is if the person you're processing data about was looking over your shoulder and seeing what you were doing with their data, would they be happy with it? That's really kind of the key question. And as I say, a lot of people sleeping rough would be really unhappy with data being shared in that way. It might be that they've fallen out with the street outreach team. They do not want the street outreach team to have anything to do with them. And yet the street outreach team, by being in those meetings, are basically, they're learning more about that person that they have no business to know about. So it matters. And you talk to people who've been homeless and people who've come out of homelessness, they're now settled and they're maybe kind of like reflecting on their time. It can bother people for a long time that actually they might be, kind of having contact with people who know much more about them than they realise. That can kind of be really kind of like unsettling for people, among other things as well. So, yeah, I would not go to those multi-agency meetings at all. You will be seen as being uncooperative. So be it. That's the game, isn't it? If you're not willing to stick up for your clients, then in my opinion, you are not right for this sort of work. People's rights come first. So yeah, I wouldn't even turn up to those meetings. I would send the information I have of the people I believe are sleeping rough, minimising it as possible, so I would not be naming them at all. I'd be ignoring kind of this stuff here. I'd just be putting unknown. And basically you're submitting that to the local authority via email. And if the local authority comes back to you saying, actually, do you know what, we want to query this particular individual here, can you provide a bit more information in order for us to cross-reference it with other information we have, then okay. Again, you want to minimise that data as much as possible. I guess it all comes back down to consent again. I can see no basis on which a charity could process personal data of a person sleeping rough unless they have their consent. And consent needs to be informed. It needs to be properly laid out to them. It needs to basically give them power over which organisations will and won't have information shared with. And even, as I say, when you've got that individual's consent, that real consent, you still can't actually share that data unless there is a need to know. So you kind of have to have this ultra conservative use of their data to make sure you're not sharing more than you need to share in order to kind of follow data protection law. So I think that covers it. That's how I would certainly get involved in a rough sleeper snapshot exercise if I knew what I was doing. As I say, I used to coordinate these things. I had no idea what I was doing. Luckily, when someone pointed this out to me, rather than kind of digging in, I did actually go and do my own research and realised, yeah, I'm actually breaking the law quite a lot. So yeah, that should kind of contain the information you need to at least kind of get you thinking about these kind of settings, because it actually applies to much broader settings than just the rough sleeper count. It would apply to multi-agency meetings about rough sleepers in general, and if that's any homeless person. But I'm just going to finish this video with just this kind of appendix about Martha Nussbaum's work on objectification, because it's just what might help you understand why this matters so much. So Martha Nussbaum, I guess you could describe her as a philosopher. She's kind of like, I think she's still alive actually. She's very, very smart, basically. Written about a wide range of kind of things, and in the 90s she wrote a paper about the objectification of people, and there's some wider context to it. But I would say, I'll let you decide for yourself whether these criteria that she basically suggested would apply to people sleeping rough and just people in the homeless sector in general, people kind of relying on the homeless sector. So there are these 7 kind of characteristics of objectification, and I think all of them would apply to people sleeping rough in certain situations. So number 1, instrumentality. The objectifier, so that would be the organisation that's processing the data, treats the object as a tool of his or her purposes. Now, we don't always see this, but we sometimes see this. I've certainly seen it, where, for example, you are having services, as I kind of mentioned before, where they're actually potentially politicising these figures in order because they know there's funding available for higher numbers. So they kind of they're losing sight of what's really going on there, and they're just kind of playing that stat game. I'll mention it just in passing. If you've not seen The Wire, the TV series from the noughties, watch that show. It's unbelievably cool, and the same kind of things you see in that show happen all the time in lots of other sectors, in terms of how stats are kind of manipulated in order to kind of meet political ends, and also because funding's involved. So number 1, instrumentality. Secondly, denial of autonomy. The objectifier treats the object as lacking in autonomy and self-determination. So you see this in a number of ways with people sleeping rough, where they are excluded from meetings about them. They're not told what they need to know in order to give consent, those kind of things. And they're not kind of given the choice about what sort of housing options they might have. So there might be a professional meeting where the professionals, the experts, essentially decide where that person should move into without even thinking that the person might have an opinion about that matter. Thirdly, inertness. The objectifier treats the object as lacking in agency and perhaps also in activity. So this is linked to the last one. So the idea that the person's wishes and kind of preferences and the fact that they can make a choice is just overlooked by the sector. And again, you see that a lot in these multi-agency meetings where when you talk to professionals, what does the person actually want to happen? They simply have never even thought to ask them. Fourthly, fungibility. The objectifier treats the object as interchangeable, A, with other objects of the same type, and or B, with objects of other types. You see this not a lot in the sector, I think, where because you've got so many homeless people, you've got more demand for housing than you have supply. Organisations don't really need to worry about providing a good service. So if you Google a charity and you look at the Google reviews, it can often be very telling. Some of them have got outrageously bad scores. And it's because it doesn't actually matter if they do a good service or not, because they know that if they get rid of one person, there's 10 more people queuing to get in. And so it doesn't really matter to them who's filling their beds. You see it in supported accommodation. It doesn't matter who's filling their beds as long as they're getting the housing benefit income. Fifthly, violability. The objectifier treats the object as lacking in boundary integrity, as something that is permissible to break up, smash and break into. Again, so boundary integrity is a really good way of understanding the right to a private life. We've all got a right to a private life, and yet when people are homeless services, myself used to be included absolutely in this, we just didn't see that what we were doing was highly intrusive, and just anyone would object to if they kind of had had an understanding of what's going on. Sixthly, ownership. The objectifier treats the object as something that is owned by another, can be bought or sold. So maybe I've seen this occasionally in the sector where you've got maybe one organisation is morphing into another. There's maybe a 2P process or something where one organisation's lost its funding, it's going to another, and all the clients just kind of naturally get migrated across, but they don't know what's happening. They don't know what the implications of that will be. And and this idea that effectively services own their clients. So we even kind of hear services talking about are homeless. It's just a very interesting way of kind of using language to talk about homeless people. And then finally, seventh, denial of subjectivity. The objectifier treats the object as something whose experience and feelings, if any, need not be taken into account. And again, this is why the whole kind of lived experience movement at the moment is so cool, because it basically repeatedly tells the sector homeless people experience homelessness in a way which we just don't understand if we've not been homeless. And that way, that perception, that way that people are experiencing it matters and has a great deal kind of impact on how services should be therefore delivered to them. So you can Google that PDF of Martha Nussbaum's paper. It's really good paper in general, but this is kind of the crux of it, these 7 points. And as I say, I think the way that people's data is shared when they are homeless would kind of raise questions about all 7 of these different characteristics of objectification. And as I said at the start, I don't think homelessness can be ended until we treat homeless people as being actual people with actual rights that shouldn't be impinged upon, with actual opinions about what sort of housing matters, with actual wisdom about how housing services should be delivered. Until we can do that, I'm not saying that in itself is going to fix everything, but I'm saying until we can do that, we're simply not going to be able to get any further along the road in terms of ending homelessness. For other reasons which I haven't got the skill to explain right now, but I'll maybe do another video about that when I can work out how to articulate it. But hopefully that's useful. Number 1 rule is, if you are processing someone's data as an organisation, you are the one responsible for it. The fact that Homeless Link might have given guidance which has kind of caused you to breach someone's rights is not an excuse. The fact that you've signed a data sharing agreement which actually isn't lawful is not an excuse. You are handling the highly sensitive information a lot of the time about people who are very vulnerable, and you need to give that the correct level of respect.